everybody. This is our fifth session of our Performing Arts Archiving Cohort, also known as PAAC Zoom series. My name is Cora Barnes. I'm the Senior Program and Development Associate at World Arts West. And the archive lead. My pronouns are she, her. So Dave is going to give us a presentation about the basics. What is copyright? What rights does it protect? How is it used? What you should know if you're a performing artist or someone who documents the performing arts. Maybe what you should know when you're entering a contract so you can fulfill your rights and responsibilities. So right now I'm going to go ahead and introduce Dave. Thank you, Dave, for joining us. We really, really appreciate it.
Thanks so much for having me. I appreciate it. It's great to be here. And as you said, I know that this focus is on archiving, and that's what this Performing Arts Archive cohort is about. When Cora and I were discussing this topic, as far as copyright for archiving goes, it's based in the fundamentals of copyright. So a lot of what we'll be talking about today is really just about copyright, for lack of a better term, copyright basics, copyright fundamentals. Because without laying that foundation of copyright and how it all works, kind of loses its value and punch if we can't talk about it in context. So also, as Cora said, definitely welcome all of your questions, and would love to basically, ultimately what it comes down to is that I'm here to answer your questions. I'm here to provide information to you. So please pop your questions into the chat so that I can make sure we're answering those questions. If something comes up that I know I'm going to get to on a later slide, I might not answer that question right away, but we'll definitely leave time for questions at the end as well, so that we don't miss anything and everyone gets all the information that they need. So a little bit about me, just to get started. As Cora said, my name is Dave Ratner. I run a law firm called Creative Law Network. We focus on providing legal counsel to creative people and businesses. And that came from a kind of a history that I have in the creative field. I am not a musician myself, but I worked in the music industry for a long time. I was a tour manager, I was a band manager, and after managing artists for many years, I realized that all my artists need a lawyer, and so decided that was meant I should be going to law school. And here we are, decades later, that somehow I've managed to keep that going, because really there's so much crossover between these different practice areas. The main thing is that what I learned coming out of the music industry was that the through line between music and every other creative field is copyright, because copyright applies to all sorts of creative works. And therefore, whether we're talking about music or dance or theater or poetry or film, all these different things are protected by copyright. So whatever your archive is, chances are it involves copyright, even though I know there's a lot of performing arts and dance focused stuff going on with World Arts West. So that is a bit of a setup just to get us in the right perspective. Copyright is a type of intellectual property. So intellectual property is property. It is something we can own. It is something we can buy and sell. It's just not something we can touch. It's intangible property. So there's different types of intellectual property. We have copyright, we have trademark, we have patent, we have trade secret, just because a lot of times these different things get confused. But copyright is a type of intellectual property, the type we'll be talking about today. But just so we understand, there's a larger area of intellectual property. Copyright is a subset of intellectual property. So the things, as I mentioned a moment ago, copyright protects all sorts of creative works, and this is, by the way, this list of creative works that are on the screen right now is from the copyright statute, the federal law that sets up copyright. So it covers literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and videos, as well as architectural works. So it shows really the broad spectrum of what we consider creative, what is susceptible for copyright protection. And and what it means to have a copyright. If you think about what it, as a copyright practitioner, as people who work in copyright, this helps us see copyright is everywhere, right? We see it all over the place, whether it's the mural on the wall outside the building, whether it's the music playing in the cafe that we're sitting in, or the recipe book, the cookbook that's on the shelf. All these things are protected by copyright. And I think it's an idea of like, we have this thing, we own a copyright, but what does copyright ownership mean? What copyright ownership means is the owner of a copyright has a set of exclusive rights, which means the owner of the copyright is the only person allowed to exercise these rights. So this is the list of these exclusive rights, again, straight out of the copyright law. And what this means is if you own a copyright, you are the only person allowed to reproduce that copyright, to prepare derivatives of that copyright, to distribute that copyright, to perform that copyright, to display that copyright. And then perform by digital audio transmission is a little wonky. We don't have to worry about that. But preparing a derivative work is an important one. A derivative work is a work based on an original. Easy example is I write a book. I own the copyright in that book. We make a movie out of that book. That movie is a derivative of the original. Okay, but so is the sequel to that book, or the prequel to that book, or the comic book version of that book. These are all derivatives. And why that's relevant here is because that means if someone owns a copyright, they're the only ones allowed to make derivatives. Someone else can't make a derivative without permission. So in phrasing this as if you own a copyright, these are your exclusive rights. The flip side of that is if someone else owns a copyright, they own those exclusive rights and no one else can do this. So if we see, and I get this a lot with a lot of people I speak with, if we see something out there that we want to use, we want to make copies of it, we want to create a derivative of, if it's protected by copyright, we would need permission from the owner, because only the owner has this set of exclusive rights. So who is the owner? And by default, the author, the creator, is the owner. So in copyright language, we use the word author to describe the creator, and we use the word claimant to describe the owner. But basically, whoever creates the work by default is usually the owner of the copyright in that work, which is kind of intuitive, right? It's like if I were to paint a painting, by default, you would think I own the copyright in that painting. There are exceptions to this. The most common exception is what's called a work for hire. So work for hire is when a company hires an individual, or a person hires an individual. The copyright created by that individual is owned by the hiring party. So the company will generally own the copyrights created by their employees. So by default, a work for hire automatically exists if an employee, which means full-time employee, W-2 employee, not a contractor, if a full-time employee creates a copyrighted work, and the creation of that work is within the scope of their employment, then it is a work for hire. This is not a very common situation in the creative world, right? Most creators are not full-time employees. There are certainly plenty of examples. If you're an animator for Disney or for Pixar or something like that, right? Your job is to create animations. Certainly there are musicians that are full-time employees creating background music or working for a symphony or something like that. So there are examples, but a lot of copyrights are created by workers, by contractors, but not always by employees. So work for hire is fairly narrow, but ownership of a copyright can also be transferred in writing by contract. So I can hire someone to create a copyright work, and in that contract can say, this is a work for hire. There's some specificity that there's only certain types of work we can do that for, but copyright ownership can also be transferred, which means just like any other piece of property, right? Just like we can buy and sell a house, we can buy and sell a car, we can buy and sell a table. Any of these things are property. Copyright is a type of property. It can be transferred, but that transfer does have to be in writing. So unlike, I don't know, like I said, I'm buying a table from someone I found on Facebook Marketplace. I can show up at their house. I can give them $20. I buy the table. There's no written transfer. for there to be a transfer of copyright, it does have to be in writing. So if we are, for example, gaining ownership of copyrights for our archive, the fact that someone said, "Oh, I'm going to give you, I'm giving you these copyrights," the verbal transfer is not sufficient for the law. There does have to be a written transfer. Whenever I talk about written transfers, people say, "Well, is a text good enough? Is an email good enough?" Yeah, it's better than nothing, but not ideal, because ideally we do want someone's signature on that transfer. And basically because we need to be able to prove that that transfer is legitimate, right? And kind of, even though we are in a digital age, we still, in the law anyway, we still rely on a lot of more antiquated systems of signing things. But for a lot of things, a digital signature can work. There are times when we use notarized signatures for copyright transfers. It is a bit of a fact-specific situation that we want to be aware of. Just depends on the facts of what is being transferred by whom, under what circumstances. But the point is that we don't, as I said a moment ago, by default, the author is going to be the owner, but that ownership of copyright can be transferred, whether it's a work for hire, whether it's by contract. Those copyrights can be transferred because, like I said, they are property, and property can be transferred. Ownership can be transferred. So it is important to think about, okay, if we're using stuff for an archive, who is the owner? Who does have that set of exclusive rights? So that we're clear on what are our rights as an archive to be using them. So that is just kind of overview of that aspect of these things. One of the things that's often surprising to folks about copyright is how long copyright lasts. So copyright, the length of a copyright is that we refer to as the copyright term. And currently, copyright term is 70 years after the life of the author, which means if I were to write a poem today, I own the copyright in that poem, that copyright exists until 70 years after my death. It's a very, very long time. And that is particularly relevant because we're thinking about, well, this person created this copyright a long time ago. So is it still protected? When someone painted this painting a long time ago, is it still protected by copyright, or can we use it? Is it no longer protected by copyright? Has that copyright term expired? And like I said, since the copyright term lasts for 7 years after the life of the author, it takes a long time for it to expire. Just to make things more complicated, the copyright term for a work for hire is different. If it's a work for hire, it's 95 years after first publication, or 120 years, after creation, whichever expires first. So the shorter of 95 years or 120 years. So again, a very, very long time. Basically, if someone is still alive, almost certainly, if someone's still alive and they created wasn't a work for hire, then it is very likely still in copyright protection, very likely. Although people are living older and older, but what happens is once a copyright expires, right, that creative thing still exists. It's still out in the world, right? Shakespeare, we also have Shakespeare's plays. They're still out in the world. They're just not protected by copyright. They're in what's called the public domain. So when a copyright expires, that creative work enters the public domain. Now, the public domain is not a place we cannot go visit, but it is the phrase that we use for describing where things go when the copyright expires. And what happens when a copyright expires is anyone can use it. So that list of exclusive rights that I had posted a few slides ago, the right to reproduce, display, perform, distribute, once the copyright expires, anybody can do that. So I can go take Shakespeare's play and I can go make as many copies as I want. I can go publish it, I can distribute it, I can go perform Shakespeare's plays. And things more recent than that. In fact, we kind of have, as copyright dorks, we have copyright, the day each year when all the copyrights expire, the end of the year. And then a list that is published. In fact, it was a couple years ago when the copyright for Steamboat Willie, which is the original Mickey Mouse, expired, which was kind of big news because Disney is very, very protective of their copyrights. Disney would not let anybody use Mickey Mouse in any way. And when that copyright expired, people said, oh, well, maybe I can go make a Steamboat Willie t-shirt or pin or movie even. And so when copyrights expire, it can be a big deal because anyone can go use them. The Great Gatsby was another one. The Great Gatsby, that book, the copyright in that book expired. Anyone can go print as many copies as they want. Anyone could go make a movie at The Great Gatsby. Someone actually wrote I believe someone wrote a prequel to The Great Gatsby. Yeah, someone wrote a prequel, which you couldn't do before because that's a derivative work. That's one of the exclusive rights protected by copyright. But once that copyright expired, anyone can go and create the prequel. So that has happened. So just as context, 95 years. Well, I should also mention the 70 years that I mentioned, the 95 years that I mentioned is the current law. That is not how it's always been. So the copyright law has changed over the years. And so the copyright term has changed over the years. So that 70 years hasn't always applied. And so unfortunately, the figuring out whether something is still protected by copyright can be a little tricky. There was a time when copyright terms basically renewed. You basically, instead of having one 70-year term, there were two 28-year terms. So originally there was a 28-year term, then there's a 28-year term plus a 28-year extension. And so there were times when you had to renew. There was a time when you had to write the copyright notice to get a copyright. So there's a lot of investigation that can go into determining whether something is protected by copyright. So even though that 70 years and 95 and 120 years are the current guidelines, it's not always that simple of a calculation. Unfortunately, this does require some expertise, which is one of the reasons I have a job. And so we do look into that if you're kind of determined, trying to figure out, hey, is this thing still protected by copyright from 1935 or 1940 or something? We may want to do some investigation to see anything. For the most part, anything that was created before 1930 is in the public domain. The copyright has expired. And by the way, all of this is US law. Okay, so we're talking about copyrights created in the US. Every country has their own copyright law. And there is what's called a copyright convention. There's a treaty among over 100 different countries, almost all the countries on the planet, where each country respects its other countries' copyright laws. So that also doesn't mean that there's no copyright in these other countries. It just means that the law may vary in different countries. But I can only speak to the copyright law in the US. That's the only country where I'm licensed to practice law. So that's the extent of my expertise. But basically, we want to certainly know in the US, anything before 1930 in the public domain. After 1930, we want to check to be sure. The Copyright Act, by the way, was most recently, the Copyright Act was most recently revised. The most recent Copyright Act is 1976, which shows you how frequently we keep up with the law, how quickly the federal government moves. There have been minor updates along the way. It was the Sonny Bono Copyright Extension Act from the 90s that extended us to the 70 years we currently have now. There's another update in 2018. So there's little updates along the way. But again, if you're trying to research this stuff yourself, just know it does change over time. So one thing that I want to make sure to cover, because I know we have a lot of performing artists and a lot of dance that's involved here, is the copyright in choreography. Because I mentioned a little while ago, copyright protects all sorts of creative works, music, film, television, etc. Choreography is a little different just because it's kind of like one thing about what a copyright is protects any sort of creative work that is fixed in some way. The copyright law says a copyright, in order for a creative work to be copyrighted, it has to be fixed in a tangible medium of expression. What that means is it has to be captured. You have to be able to show it or prove it, generally recorded. When the copyright law was written in 1976, we captured things by writing them down, generally recording them, audio, video, etc. They weren't ones and zeros on our computers as they are now. So capturing on a computer is still a capture, is still a fixation, but you have to somehow fix that creative work in a way you can show it to others. And that's what makes something has to be sufficiently original to be copyrightable, and it has to be fixed in some way. So I mention that in the context of choreography because a lot of times it's like, well, I created this I choreographed this work, but how is it fixed? Right. So choreography, in order to be captured, basically we're going to fix it. They do define a choreographic work. And we have these definitions that are on the screen right now. Basically, rhythmic movements of one or more dancers' body in a defined sequence and defined spatial environment. It can also be a series of dance movements or patterns organized into an integrated whole. It can be a story, theme, or abstract composition. One of these things generally has to be true for that choreographed work to be susceptible for copyright. There's actually a case recently, the Carlton from the Fresh Prince of Bel Air, right? So from that show, there was that dance move. It was, I don't think it was Roblox. It was yes, exactly. And the TV show, yes, it was Fortnite. Thank you, Noel. So Fortnite used that dance, and the creator of the dance tried to say, Fortnite, you can't use that because that is a copyrighted work. But that one move wasn't sufficiently substantive to be considered a choreographed work that could be susceptible to copyright. Same thing, if I write a simple phrase, that is not protected by copyright, but a poem is protectable by copyright. So it has to be sufficiently substantive in order to get copyright protection. And this certainly is related to copyright in choreography because there has to be enough to it, more than just one move, basically, for it to be copyrightable.
So,
Uh,
Dave, I have a question. I love how you brought that up because me and my boyfriend were just talking about this. So, like, I know that right now, like, there's TikTok dances, dance credit by me, and all that stuff. And I know that, like, I think every entity has caught on to how quote unquote viral has this gone. So, you're saying that the Carlton move, because it's a singular thing, it doesn't count as copyright? Is that what it is?
Basically, yes. I mean, the reason that
Oh,
that suit was unsuccessful was
got
because the
it.
court determined that that one move was not enough to be
That
copyrightable.
that Fortnite teamed up with a bunch of K-pop groups, and there's a bunch of K-pop in there now, and it's not just one move, it's choreographic. I think therefore, like, because it's like, I don't know, in layman terms, I guess like 4, 5, 8 counts, that would count as choreography, right? Instead of just being one move.
The hard thing about copyright
Okay.
is that it varies a lot. It is also ultimately determined by a judge, and judges have a little bit of subjective judgment. The reason I mention this is because when you say the 4, 5, 8 bars, um, that has been a big issue in music, right? We get a lot of a lot of time the music copyright infringement suits get a lot of press. The Blurred Lines case with Robin Thicke and Pharrell was a big one recently. There was one about Stairway to Heaven not too long ago. And this goes back decades. I mean, there's just a long history of copyright infringement suits about music. The reason I bring it up in this context is there is not just a single certain number of notes or certain length of number of bars of music that makes it an infringement, right? If you're using a certain number of notes that are the same notes as someone else's song, is that an infringement, right? And we don't have a set rule on that because creativity is variable and subjective, right? So these copyright infringement suits, and I'll talk about infringement a little bit, are about using someone else's copyright generally for a derivative work. This song sounds like this song. This move looks like this move.
Uh, okay.
And in order to prove infringement, you have to use enough of it. So if we're just using a couple notes or a bit of a couple moves, is that action infringement? Is that using enough of the work to constitute an infringement?
And it's not
And
up to
that
you. It's up
it
to,
varies. It varies a
okay.
lot. So
Thank you.
that comes up in this as well. Yeah, absolutely. The other thing about choreography, by the way, is the fixation part of it, right? So how do we say that that a choreographic work is fixed? Because I mean, certainly video is the obvious one, but notation can also constitute fixation. Textual descriptions, photos, drawings. So there are multiple ways to fix, to record choreographic works for the purposes of copyright. Again, it's a little bit more simple, like a written work is in writing, right? And a music is usually audio recording or audiovisual recording, right? So with choreography, it's a little bit trickier. And that is what we're looking for when we have that fixation that has to be fixed in some way to have copyright protection. So this also brings up what is not protected by copyright. And the most basic thing is ideas are not protected by copyright. Because I get this a lot where it's like, I have this idea for a movie, I have this idea for a dance movie, right? The idea is not fixed. So it has to be recorded in some way. That movie has to be there, has to be a script or a treatment. That song has to be notated or recorded. That poem has to be written down. That story has to be written down. And that choreography does have to be fixed, recorded in some way. Now, as we were kind of just talking about, commonplace movements, just basic steps in choreography, are not usually going to be protected. Also, social dances, ballroom line dancing, things like that are generally not protected. Also, this may sound silly, but routines not performed by humans are not protected. You've probably seen videos of robots dancing, not going to be protected by copyright. Robot AI is a whole other world as far as that goes, because things that are created, if something's created by a machine that's not protected by copyright, a human, generally to be protected by copyright, it must be human created. I know I see Sam posted a question here. Folk traditions, people's knowledge, even though stage works can belong to an individual artist, shouldn't ethics? Yes, so there is a lot about folk traditions, and this happens in a lot of different ways. I mean, there's a lot of traditional music as well, or hymns in religion. There's a lot of things that have a long history that are not protected by copyright. Now, what does happen though is that adding your own creative expression, making changes to it, can be protected by copyright. So what happens here is, for example, a book of poems, or rather, I'll use it better, a book of Shakespeare's plays, okay? As I said before, Shakespeare is long dead, his plays are no longer protected by copyright. However, if we take them and compile them, organize them in a particular fashion, write a forward to that compilation, create cover art for that compilation, we've added our own creative work to that book of plays. What we have added is protected, even though the old stuff is not protected. So I don't know how this applies, how much this applies, Sam, to what you're saying, but like what happens is when we have a lot of traditionals in a lot of different creative expression, whether it is dance or music or written word, we have traditional works that are not protected by copyright. When we add to them, what we add to them can be protected, even though the original is not protected. There's certainly a lot of appropriation issues we do have to be aware of. I'm definitely aware of that. And I think the main thing is that you're not, by creating your own fixation of something traditional doesn't mean you own it. You can't gain ownership of what someone else has. It's only what you add to it that can be protected by copyright.
Dave, I'm going to
Yeah,
just add on, I think, a little bit to that question,
sure, please.
which is, a lot of the dance companies that we work with are culturally rooted dance companies. So that means they do maybe traditional dance or folk dance or sacred dances. And so in a sense, those things have been the same for, since time immemorial. But
Right.
also there are absolutely choreographers who are taking that traditional dance and creating their own visions and versions of it. And so is that where you're saying that that's where that might be protected as far as your choreography?
Correct. Thank you, Cora. Yeah. I will also say, again, there's a lot of gray in copyright, right? It is a lot of subjective, a lot of gray area, and it can be frustrating, but also it allows for the creativity. I think that's one of the reasons we have this gray area. I will say, copyright is actually in the U.S. Constitution. You want to look, Article 1, Section 8 says that we should protect And then the idea behind it is by granting copyright to creative works, we're encouraging creativity, right? Because if your creative work wasn't protected, there's no financial incentive to create. Now, I know we don't all create for financial incentive, but this is the same idea behind patent, and patent protects inventions, which there oftentimes is a financial incentive. But the idea is, if when you created a copyrighted work, painted a painting, wrote a book, created a dance, and anyone could go steal it, and you don't have to get paid for that use, there's not the financial incentive. So that's kind of another side to copyright, if that helps explain things a little bit. But Corey, you did a good job of explaining of exactly what is protectable when we're adding to traditional and prior works. And that also applies, by the way, if you're using someone else's, if you get permission to use someone else's copyright, you add your own thing to it. You get permission to add your own thing to it. You can own what you added to it. Again, that's going to be subject to that agreement to use someone else's work. I see Galen asked the question, how much does it matter if a performer is paid or not for presenting a derivative work? So payment isn't required for a transfer of ownership or a license or anything like that. I get this a lot when people say, well, I'm using this other work, but I'm not making any money off of it. Therefore, it's not an infringement. Therefore, I don't need to get permission. But that is not the case. Because I get this a lot, for example, they have a lot of music where people say, well, I'm making this mixtape, which is obviously using other people's music. I'm making this mixtape, but I'm just giving it away. I'm not selling it. Therefore, it's not infringement. That is not true. Because if you take that to the extreme, right? I took this person's book and I'm making a bunch of copies of the book and I'm just going to give it away because that'll help get the book out there more. That person could be selling copies of their book, right? They should have the opportunity to sell the copy, or at least control how the book is presented and where it is sold and such. So the payment doesn't actually, it is a factor in determining a use, but not the controlling factor. Let's see, another question was, could you also talk a bit more about using recorded music for dance performances, especially if that music is available on YouTube and other streaming platforms? That is a great question. Because everything is available online these days, right? So you can very easily find just about any music, any video, it's all out there for the taking. That doesn't mean we can go use it for any other commercial purpose, because what's happening is when music, I'll kind of stick to the question here. To use someone's recorded music, that set of exclusive rights that I spoke about at the beginning includes the rights to perform, which means if I write some music, if I own the copyright in music, I'm the only one who has the right to perform it. Perform means playing it over a speaker, basically, or playing it in an audible way. So if I'm playing it live, if it's getting played out of a loudspeaker, that requires a performance license. Now, I'm going to talk about licensing a little bit, so I will get to that when you're using recorded music for dance performances. So let me get to that slide in just a little bit. So that can keep me moving here. So keep me moving. That's a good thing. The one other thing I want to make sure to mention about copyright, because again, I've been saying it's intellectual property, it's still a type of property, but this also often can get confused, is ownership of the physical thing. Because we see this varies a lot with the different type of work we're talking about. I see it very common with visual art. So someone buys a painting, they think they own the copyright in that painting. That is not the case. The example I can give you is, for those of us old enough to remember CDs, or shiny things we used to buy that have music on them. When you bought a CD, or if you buy a CD, you didn't buy the copyright. You bought a copy of it, right? Because there's millions of copies of a CD, you didn't buy the copyright. So same thing here. Even if you pay to download a song, it doesn't mean you can go and use it for your performance or on your video or something like that. So I always make sure to mention that owning the physical thing does not equal ownership of the copyright. And that's an important distinction. Hopefully it also helps to illuminate the concept a little bit more, which is also, I think, helpful, just helping us frame it in our minds. But I do want to talk about infringement a little bit because I've been mentioning it along the way here. And just to explicitly say that what infringement is using a copyright without permission. So basically someone else owns the copyright, you use it without their say-so, without their agreeing to that, that is infringement. When any one of those exclusive rights is exploited without permission. So if you reproduce a copyright without permission, if you distribute a copyright without permission, if you perform a copyright without permission, if you create a derivative work without permission, and that the creation of the derivative work is the most common. Those are the copyright cases we hear about, like I said, the blurred lines case, etc. But it is, I'm not trying to scare anybody here, but it is a violation of federal law. So I talk about the penalties are, which can be payment of the profits you received, damages of up to $150,000, restraining order, confiscation. I mean, all sorts of gross stuff that we don't have to deal with. So not that I need to discourage you creative folks from using someone else's copyright without permission, but I always make sure to mention it because when we have discussions like this, there's often people on both sides, people who own copyrights and people who are using copyrights, or sometimes that's the same person, right? A lot of us are, right? We create our own works, we use other people's works, we want to understand both sides. Also, because if you own copyrights and you do see someone else using your copyright without permission, that is something you want to know. Hey, what constitutes infringement? Can I go after them? That's a whole other presentation. We can talk about infringement and what the law says and how all that works, but try not to focus on the negative. But there is a lot to that. There's a lot of detail into how all that works. And I will talk a little bit about getting permission because clearly there's the ability, we do use other people's copyrights. That is how the world works, right? There is the opportunity, and we do obviously have the opportunity. We see that all the time. We see people using other people's copyrights all the time. We see some music in a film, or as we're talking about music in a dance performance. So permission is doable. One of the hard things about getting those permissions is sometimes figuring out, well, is that thing still protected by copyright? Who owns that copyright? And as I mentioned earlier, most things that are modern are protected by copyright because of that 70-year term. There is, the Copyright Office does have a database of registered copyrights, which is a good place to start looking. One thing that's important to know about that registration though, so copyright exists as soon as we create a copyright work. So we say as soon as we lift our pen from the paper, a copyright exists. So once I record a song, write a poem, paint a painting, video my dance moves, there's a copyright. We have a copyright registration system through the US Copyright Office, and that registration is the legal proof of ownership. So if you ever had to file for infringement, if you owned a copyright, someone else stole it or infringed it, used it without permission, you'd need to have that registration in order to pursue an infringement action, to take them to court, basically. People often say to me, well, if I own the copyright as soon as it's created, why do I need to go and register it? Because registration takes time, costs money. And that is the main reason. It's the legal proof of ownership that you need to pursue infringement. So for a lot of us, if we are going to be putting our stuff out in the world, we may want to consider, if we putting it out in a way that we might worry about an infringement, might want to consider registration, which you can do through the Copyright Office. It's copyright.gov. Our firm also does copyright registrations for folks. It can get a little tricky. Yeah, Cora.
So does that mean, Dave, if you created a work 10 years ago and then somebody infringed on your copyright, could you go register now and be like, I created this 10 years ago, they infringed upon it? Or is it just
You
like,
can.
or it's just like, is there any way to, observe that infringement currently if it's not a registered copyright?
Yes, so you can register after the fact. Ideally, you're going to do your registration within 90 days of publication, but you can do a registration after the fact. It just doesn't provide protection for before the registration. So if you notice an infringement today and you do an infringement tomorrow, the infringement that happened today is not protected by that registration you do tomorrow. If that infringement continues after tomorrow, that registration will help in that situation. So,
Mm.
yeah. Yeah, the Copyright Office registration process is a little tricky. Got to just read very carefully. The instructions aren't very clear sometimes. They have some tutorials, but registration is certainly worthwhile. Again, the filing fee is $65 to $85 per registration. So that's another thing that's, the financial considerations. You can't, we have to do generally a registration for each distinct work. Grouping them is pretty tricky. They want you to spend that fee. They don't want to let you group a whole bunch of them together. So, but the Copyright Office registration process is still an important one when we're talking about infringement. So, but I was talking about, right? So if we do want to use someone else's copyright, that is certainly doable. We just have to get a license, right? So a license is basically permission to use someone else's copyright, very basically, right? It says, I own this copyright. I'm granting you a license so you can use this copyright. You can exercise some of those exclusive rights. That's the idea behind it. And so licensing happens in a few different ways. There can be a direct license from one person to another, but there's also something called a blanket license where, right, so you can get permission to a whole group of copyrights through a system, and I'll talk about some of those systems because I want to make sure this gets back to the question about using recorded music for performances. So these are generally two types of licenses. I'll kind of explain each one briefly. A direct license is what we think about if we say, I want to, there's that there is that that musical. Okay, so we want to perform that musical in our theater. We want to perform that musical. We're going to go and get the permission. We're going to go get permission from the publisher, and they're going to send us all the scripts and all the charts and everything. We're going to pay the fees that they charge so we can present that musical in our theater on these dates for this fee. Direct license. Or this person wrote a book. I want to make a movie out of that book. I'm going to get a contract from them that says I can go create that derivative, and there's a license. Or when we do mass publication, so musician records an album, and when that album is put out by a record label, that is generally a license as well. The musician said, I own this copyright. I'm going to grant the record label a license to go and reproduce and distribute the copyrights in that music. So licenses come in a lot of different ways. But I want to make sure to mention that when we're talking about a license, a lot of us will go and say, well, I need this license. We're going to go write a license. And certainly I encourage you to use legal counsel whenever possible to draft a license or draft any contract that you're doing. But I also recognize we can't all be hiring lawyers for every little thing we do. And I make sure to mention, people say, oh, I'm going to go draft my own license. Okay. It has to be detailed. A lot of people say, oh, I draft a license that says I can use this thing. Well, what is this thing that we're using, and how are we using it? Are we making copies? Are we distributing? Are we performing? Are we displaying? And in what formats? Is it digital? Is it physical? Is it social media? Is it just on a website? In what territories? Is it just in the US? Is it worldwide? Is it US, Canada, and Mexico? How long does this last? Can we just do it for a month, a year, in perpetuity? What are we getting paid? Is it a flat fee? Is it a royalty? How often is a royalty paid? There's just a lot of these details that go into, well, any contract, but specifically a license agreement. So if we want to be using someone else's copyright, or if we want to allow someone to use our copyright, we want to make sure we are including these specifics. Okay? So just to give an idea of what goes into those details. Yeah, Coral.
So I want to make sure, Dave, that we get to Sam's question in the chat. I know it looks long, but it's what it's what a lot of us are dealing with, including World Arts West. Any
Okay.
performers who are working with, either putting out their whole archive or working in festivals or any of those things. We're like, we have all of these recordings, we have all of these photographs that we want to be able to share in our archive, and to do that so we're not stepping on anybody's rights, but also no one stepping on our rights. And be able to put that out in an ethical way. So I
Mhm.
think that's really important. I'll give an example. Like if what may be happening with SAM, what's happening with World Arts West and other organizations, we put on a festival or we have a performance and the dancer comes or the choreographer comes, they present a work, right? And so that's one thing. But then the videographer comes and they document it. But then we hired all of those people to do the work. So like where are we wanting to be with making sure that we um, are conscientious of other folks' copyrights, but also being able to share with the community what we've produced?
Sure, absolutely. Very briefly, a lot of contracts.
I,
So I want to get to Shika's question first,
oh, I'm
because
sorry. I missed
that's
it.
okay. And then I will get, and then
Yes, thank
I know
you.
we want to talk about archives specifically for that. So just the last thing is Shika's question was about using music for a performance. And
Yes.
this is where blanket licenses come in.
Ah,
Because blanket license, so ASCAP and BMI are music performing rights organizations. So performing rights organization grants the right to publicly perform music. And this means a public performance is playing out of a loudspeaker, playing to a group in any way, which means when you walk into a coffee shop and there's music playing, that is a public performance. But just like if you walk into a music venue and there's a band on stage, that is also a performance. So when we are performing music, a lot of times that can be licensed from one of these performing rights organizations, which again is a whole other separate presentation about how all that works. Those performing rights are what we call non-dramatic performing rights. If we are dramatizing music, okay, if we're using music to tell a story, which is more like musical theater, not as much using music as for a dance performance. Musical theater is a dramatic performance which requires a direct license. So with dance, it's a little tricky. Generally, most dance can be done with these performing rights organizations, what we call PROs, ASCAP, BMI, and CSAC. And the direct, or rather, a dramatic performance requires a direct license. So I wanted to make sure to mention that. So getting to the archive, I appreciate, Corey, you explaining Sam's question because I did not have a chance to read it, which seems like actually, well, let me answer your question first, Corey, which is that we need to be, I think it's very helpful to think about copyrights when we're planning these things and the different people involved. So if we have a performer on stage, they are presenting their copyright. That videographer is creating a new copyright with the video, right? So we need permission. We want to have permission and deal with the performer who's going to be performing, and if they're getting paid or whatever consideration there is. And then there's also an agreement with the videographer who's capturing this performance. We need the performer to agree that we're going to have the videographer capture it. But that videographer agreement says who owns the copyright in the video and what can we do with it? Are we paying that videographer and we own the copyright? Or is the videographer going to own the copyright and grant us a license? So that all goes in contract, which is why my quick answer was we need a lot of contracts for these various relationships. I know Sam's question was developing an archive that includes hundreds of musical pieces. And I think basically, let me see, does making archive. So, I mean, yes, if you are creating an archive of works that are protected by copyright, you technically need permission from the owners to do so, to again, to make copies, to distribute, etc. I know it is oftentimes very challenging to do that, and there are certain exceptions for what we call fair use. And fair use is an entire area of copyright law that can be very subjective and hard to nail down, which basically is one of the reasons I don't delve into it in this kind of short, although hour that we have, which runs away very quickly. So but the idea is, I mean, unfortunately, I understand that we're trying to accomplish great things with archives, and you would think, well, I should be able to do this and not have to worry about infringing someone's copyright. And it does depend. There's a lot of specifics involved here, because, for example, depends on what that archive is. If we are, for example, like I will drastically simplify here. I'm creating an archive by collecting thousands of CDs. That is fully fine. I'm just buying and selling CDs. There's nothing illegal about that. If I'm making copies of those CDs, that is a copyright protection issue because I'm reproducing, I'm using the copyright, I'm exploiting that copyright for my own purposes. So the detail of what creating an archive is and how we're doing it really matters, as well as the concept of fair use, because there are exceptions to these copyright protections when it comes to fair use requires an analysis, basically, of 4 different factors that can determine whether sometimes there are situations where we can use someone's copyright without permission because it is determined to be a fair use. So that's also something to cover. I think one of the things about this is it is very fact specific, right? Every situation is very fact specific. And even when we're talking about archives, it's very, right, depending on what we are archiving and how we are doing it, is going to dictate what copyright issues may arise. And applying the facts to the law is kind of what lawyers do, right? So certainly I am happy to talk with anybody on this presentation, anybody listening or watching this video after the fact, and put here's my contact information up here. I know it's in the chat as well, but I'm always happy to answer questions. The other thing I will say is I know that I know that attorneys are expensive. Right? A lot of us don't have the money to pay attorneys. There is many states have what's called a volunteer lawyers for the arts organization. I know California has a very robust lawyers for the arts organization. What a volunteer lawyers for the arts organization is an organization that provides pro bono legal services to in-need artists and arts organizations. So pro bono means free, which means you can apply to get a pro bono attorney to help you, especially if you're a nonprofit, especially if you're an artist that can't afford a lawyer. Then that's what these volunteer lawyers for the arts do. And the California Lawyers for the Arts, like I said, California Lawyers for the Arts has multiple offices, both in the Bay Area and down in Southern California. And so you can certainly reach out to them if you feel like you need a lawyer but can't afford one. So hopefully that is a helpful resource as well.
Sounds like we might have to bring Dave back or in some other capacity. But thank you so much for all of the information you've given us today. Dave, we have so many organizations that have legacy archives that are so rich, and we need to be able to preserve them and share them, and we need to be able to navigate this. I want to thank our funder, Lyricist, for our Performing Arts Network grant that we received to be able to do this series. And I want to thank all of you for being here. Thank you, everybody, so much. We really appreciate you, and have a great rest of your day. Thank you, everybody.